Everything sounds great and sign is pin. Thank you. All right. Can you guys hear me okay? If you want to go ahead and utilize the chat to let me know the audio is good and you guys are able to hear me. Hello, William. Thank you for letting me know. Antonio, greetings. Loud and clear. Thank you. Welcome. Hello. Tanya, audio's good. Wonderful. So I keep hearing audio's good. So again, welcome to our June Healthcare Provider webinar. We're very excited to have you here to join us on the Fair Housing Act, Disability as a Protected Class, and Reasonable Accommodation and Modifications. We will also have a space for introduction, so you'll get to hear from everybody that is in the room, who is presenting and who is here supporting this webinar. And without further say, let's go ahead and go to the next slide. All right, so before we get started, let's review the accessibility information. For interpretation in Spanish, please click on the globe that has the label interpretation on it and select the language interpreter. We have two simultaneously language interpreters available with us today. So it would be Paula and Carolina. So you'll be able to see them on the interpretation name list. Now, if you are needing closed captioning in a specific language, you must click on the live transcript and subtitle settings. We also have Damon here. He is spotlighted, highlighted on the Zoom. So he'll be our sign language interpreter for today's session. And if you guys have any questions on how to utilize those functionings, or maybe something's not working on your end, please let us know on the chat. And let's go to the next. Okay, so we have a full agenda today. I know we have an hour here, so hopefully we have a space to cover and address some of your questions. But the agenda for today, again, welcome and introductions. We'll be able to do some introductions, introduce Dr. Lara and some of our subject matter experts with us today. The Fair Housing Act, so it's going to cover the disability as a protected class, reasonable accommodations and modifications. We're going to be able to go a little bit over on how to fill out the third-party verification letter, what it looks like. We'll be able to kind of show you on the screen the spaces that you will need to fill out, so how it relates to the provider side. Should you have to fill out or need to fill out a third-party verification letter for a patient. As I mentioned, we have a full agenda today, so hopefully we'll be able to have some time for Q&A. But in the meantime, your questions are welcome. So we ask throughout the presentation that Jamie is going to be going over, or Michael from Boli, to provide those questions on the chat box. We'll be able to monitor that chat bot. And if your question for some reason is not getting addressed at today's webinar, we'll be able to follow up with a Q&A in the follow-up email. And then we'll also have OHP announcements specifically to Healthier Oregon updates. So here are the introductions. So my name is Rosa Armenta. I am a regional outreach coordinator for the Community Partner Outreach Program with OHA for the Northeast region. So you'll be hearing from me, but you'll also be hearing from my colleague Alma. So I'll just pass it on to Alma to have her do her introduction.
Hi, good morning. Thank you, Rosie. So thank you all for joining us today. As Rosie mentioned, I'm a regional outreach coordinator serving the Southeast region for the Community Partner Outreach Program. And throughout today's session, you'll be hearing from both of us as we help facilitate and guide the conversation. And I would like to hand the time over to Dr. Andrea Lara.
Hi, good morning. I'm Dr. Lara. I'm the new provider strategist, and my pronouns are she, her, ella. I want to share just a little about my role. My role here with the CPOP team will be interacting with the healthcare providers and CCOs so we can improve the quality of care for the OHP community. Also approaching the equity component. Also, we're going to approach the clinical specific with preventive medicine. So we're going to be connecting community outreach and healthcare providers work. I'm happy to be here today. Next, please. So today we have the subject matter experts that are going to be leading our topic. We have Jamie from the Fair Housing Council of Oregon. Also, we have Michael from Oregon Bureau of Labor and Industry, known as ABOLI. And we have Holly and Evita from Oregon Housing and Community Services. Thank you for being today here. I don't know if Holly and Evita, they want to say hi and just quick introduction.
Sure. Hi, Evita Marnell, she, her pronouns. And Dr. Lara said I'm from Oregon Housing Community Services, and we're here just to support OHA and CPOP in their effort to educate community members and providers as it relates to the rights of Oregonians in housing. So nice to meet everybody. Thank you for having me.
Holly McGuire, she, her pronouns. I'm an operations and policy analyst with the Housing Stabilization Division, and appreciate having the opportunity to be here.
Thank you. Next, please. And now we're ready for our main topic. It's going to be Fair Housing Act. Next. Okay, and Jamie, you have the floor.
Excellent. Thank you so much. I'm so glad to be here today. Again, I'm Jamie Gatewood. I'm the Education and Outreach Manager at the Fair Housing Council of Oregon. And today, as was stated, we're going to be talking about what is the Fair Housing Act and disability as a protected class, and then go into a little bit of detail about verification for reasonable accommodations or modifications with a little bit of an emphasis on assistance animals. So I'll go ahead and get started. Can we go to the next slide, please? Thank you. So fair housing laws are civil rights laws that promote equal access to housing. They make it illegal for housing providers to discriminate against certain groups. And it's different than landlord-tenant law, something really important to note, because landlord-tenant law covers pretty much every kind of transaction that can happen between a housing provider and their tenants. So what can be part of a lease agreement, how terminations can be handled. If somebody puts in a work order to have somebody come in and fix something on their unit, how should that be handled? And, what's the timeline for that? Fair housing law comes into play when somebody's being treated differently because of their protected class identity in any of those kinds of housing transactions. So that's really the main difference between the two. Next slide, please. So fair housing is the right of all people to be treated equally in the rental, sale, or financing of housing, and fair housing protects people against illegal discrimination in housing. When we're talking about rental housing, it's important to note that these laws cover the entire process. So it could be while somebody's applying for housing, while they're already living in the unit, or during their tenancy, or even after they've received a notice to move out. Next slide. And discrimination in housing is treating a person differently in any housing transaction because that person is a member of a protected class or part of a protected class. So I've been saying protected class, certain people. Who are these folks? Let's talk about them in the next slide. So there are a couple of different sets of protected classes. We have federal protected classes, which are listed here on the screen. So that could be race, color, familial status, meaning anyone raising children under the age of 18. Sex is here, and it has these little asterisks because sex also includes survivors of domestic violence, gender identity, and sexual orientation. So there's a couple different groups that fall within that designation of sex. Also, we have religion, national origin, and disability, and that's what we'll be focusing on mostly today. Next slide. And then in Oregon, we also have additional protected classes. So Oregon goes on to protect marital status. So it doesn't matter if you're single, married, divorced, widowed. None of those things should really come into question when you're going into a housing transaction. Also, source of income. So this means folks who are using rental subsidies or other agency rental payments. So it could be a housing choice voucher, also known as a Section 8 voucher. you know, payments from like a nonprofit maybe, or another agency that's helping out with maybe late rent or just monthly rental payments, or sources of income like temporary assistance for needy families. That's that TANF down there. Social Security income or Social Security disability income. That means housing providers shouldn't be saying, oh no, you know, I'm not going to count those kinds of income to qualify you to rent, right? They all need to be taken into account. And then also in Oregon, they go on to include sexual orientation and gender identity, which were in the last slide for federal protections, but Oregon was a little ahead of the game and we added them first. And also it's important to note that depending on what city you're in, there could be additional protected classes. If you want to learn more about those, you can go to fhco.org and just type in protected classes in the search bar, and a chart will pop up for you to learn more about those. Next slide, thank you. So who has to comply with fair housing laws? The short answer is pretty much everyone who touches the housing market. So there's a long list here, you know, folks who are housing providers, landlords, housing authorities, property managers, also people who are coming onto the property, maintenance staff, or other kinds of contractors. Homeowners associations make a lot of decisions about who can live in those neighborhoods and the rules that are existing in those neighborhoods. Real estate agents, mortgage lenders, and financial institutions. So folks who are involved in the sale of housing, or in, you know, giving out or providing mortgages and things like that. Insurers have to follow fair housing laws. Neighbors, jurisdictions, so that means like cities and counties have responsibilities under the Fair Housing Act, and also advertising media. An example of illegal advertising could be here in Oregon would be no Section 8, or maybe if it's a senior community, we hear things like healthy and active seniors wanted. But if you hear that kind of advertising and you live with a disability that affects your mobility, that could really create a chilling effect and make it feel like you're not welcome there. So that's why it would be discriminatory. And it's important to note also that these laws are applied to dwellings. And the reason why we go over this is because my definition of a dwelling could be different than yours, but the enforcers of the law have kind of given us some clear definition of what they consider to be a dwelling. So it could be houses, apartments, regardless of the number of units, condos and floating homes, mobile homes, and those are mobile homes like the kind that are located in one place. They're not moving from place to place, and they're usually paying some kind of a rental fee for their space. If it's a mobile, or sorry, if it's an RV that's moving from place to place pretty often, every couple of days, they're not paying for a rental space, likely that would not fall under the Fair Housing Act. So that's why we have to go over this, so we all know where these laws apply. Also to retirement housing and assisted living facilities, a lot of nonprofit housing and shelters fall under the Fair Housing Act. If somebody's there for an extended period of time, it's their only dwelling. Likely they've signed some kind of an agreement. Usually it's like a behavior agreement, and oftentimes there's an exchange that happens in shelter housing. Usually that exchange is not for money. It's more for like an agreement that somebody says, yeah, I'll give back to the community by doing these chores to live here at the shelter. So in those instances, they would be covered under the Fair Housing Act, and possibly motel rooms too. We know that a lot of folks, because of the housing crisis and for other reasons, people are staying in motel rooms for extended periods of time. And you know, at that point, again, if those other criteria fit, like they've signed a rental agreement, they are there for an extended period of time, it's their only dwelling, oftentimes those motel rooms will start to fall under the Fair Housing Act. Okay, next slide. So when we're talking about reasonable accommodations and modifications for folks who are living with a disability, we want to start by talking about what is the role of the medical provider. Well, here are some of the roles of the person who's the tenant or the client. What they would need to do is provide verification that they meet the Fair Housing Act definition of disabilities, which we'll go over in the next slide. Clients need to demonstrate that the request for the reasonable accommodation or modification is needed to grant or restore equal access or enjoyment of housing. And the client needs someone to verify both of these things unless the disability is evident. So that means that the provider's responsibility is to verify these things in a letter and then provide that to the housing provider. We'll go over exactly what that looks like here in just a moment. Next slide. So the definition of disability under the Fair Housing Act is very broad and inclusive, and it was written that way on purpose. And it's important to note that it's different than the definition of disability under the Americans with Disabilities Act, which I think is maybe a definition that some folks are more familiar with. So the definition of disability under the Fair Housing Act is any physical or mental condition that substantially impairs a major life activity. Those activities could be things like walking, seeing, hearing, breathing, thinking, or caring for oneself. So again, very broad and inclusive definition. Next slide, thank you. So disability also includes ongoing chronic medical conditions. Some of them could be multiple sclerosis, cerebral palsy, schizophrenia, autism, seizure disorder, asthma, post-traumatic stress disorder, attention deficit hyperactivity disorder, depression, anxiety, etc. Right? There's lots of different conditions that would fall under the Fair Housing Act definition of disability. And disability also protects individuals with a history of alcohol or drug addiction, not the current users of illegal drugs. So what this means is that when somebody's applying to housing and they know that they have barriers in their history directly related to their disability of the history of alcohol or drug use, they could write a reasonable accommodation asking the housing provider to overlook that history if they can provide verification that shows what has shifted or changed in their lives. For example, they're maybe in some kind of a treatment program or receiving some kind of treatment that is for alcoholism and substance abuse disorder, and they're no longer using those things and they're clean and sober. Disability also protects individuals with a history of any disability. So similarly, if a person has maybe they have poor credit history or poor rental history or criminal history that's directly related to their history of any kind of disability, they could also write a reasonable accommodation request at the time of move-in, asking the housing provider to overlook those barriers. Again, they would have to provide verification of what has shifted or changed in their lives. So an example of this could be maybe someone has poor credit history due to paying medical bills with a credit card. And maybe that, the credit got really high and it was just hard to pay down. But now they can pay all their bills on time. So credit may still be damaged, but they're able to pay their rent and their bills are now actively, and now they're actively working to pay down that credit. And they can show that through paid bills and through other sources of verification. And individuals who are assumed to have a disability. So if somebody's being treated differently in any kind of housing transaction because their housing provider is making assumptions about them, like they might have a disability, then that would definitely fall under the Fair Housing Act and could result as a violation. All right, next slide, please. So reasonable accommodation and modification requests. Sometimes they're needed to restore equal access or enjoyment of housing for someone living with a disability. And the landlord or housing provider might need to add something to a unit or remove a barrier or make an exception to a policy, rule, or procedure to restore equal access or enjoyment of someone's housing. Next slide, please. Thank you. So a reasonable modification is a physical change to a unit. So something like adding a ramp at the entrance of a unit or adapting bathrooms or kitchens to be more accessible. Like, for example, this bathroom here has some grab bars in the shower. So those are some examples of a physical modification, also known as a reasonable modification. And then the next slide goes over reasonable accommodation, which is a little different. That's an exception to a policy, rule, or procedure. So for example, someone might make a request for a reasonable accommodation to have an assistance animal on a property that usually does not allow animals. Or maybe somebody's mobility needs have changed and they need a reserved parking spot closer to their house or to their door in a place that usually does not have reserved parking. So these would be examples of a change to a policy, rule, or procedure. Next slide, please. Thank you. So when we're talking about assistance animals under the Fair Housing Act, that's an umbrella term. And it covers trained service animals like a seeing eye dog. It covers companion animals and emotional support animals. So all of these animals are designated under the term assistance animals in the Fair Housing Act. Next slide, please. So reasonable accommodations and modification requests, they can occur at any time in the rental process. So it could be while someone's applying for housing, they can go ahead and disclose, yeah, I have a disability and I need this accommodation. It could be during tenancy or after someone has already moved in. So they don't have to disclose anything about a disability or a reasonable accommodation or modification request at the application. They can wait until they're already in housing to do that. And they can even make a reasonable accommodation or modification request after receiving some kind of a notice. But it's important to note that the reasonable accommodation or modification request would have to remedy the lease violation. So somebody could not write a reasonable accommodation to continue to break their lease. So an example might be maybe somebody has a disability that causes them to make noise or a lot of sound. And that is causing the neighbor to say, you know, I no longer have equal access to my unit because of the noise. So someone could write a reasonable accommodation request to soundproof their unit so that they can stay in their stable housing. Or maybe somebody's situation has changed and they've received some kind of treatment or help so that they don't make that noise anymore. Another example could be maybe the person makes a reasonable accommodation request for an assistance animal because they're living with post-traumatic stress disorder and they sometimes have night terrors, but this animal can wake them up before they start making noise during that night terror. So, you know, there could be a lot of different kinds of reasonable accommodations that could resolve this lease violation. The person would just have to show that that's what has shifted or changed and how that lease violation is going to be remedied. Each request is evaluated on its own merit. So we shouldn't be hearing housing providers saying, oh no, you already made one request and that means you can't make another one this month. That's not how they work. They're initiated by the person with the disability. So that person is the one who makes the request. And all residents, again, must be able to meet their lease agreement. Next slide, please. So verifiers of disability. So this could be y'all as medical providers, or it could be maybe someone else. They should be a qualified individual who knows the person's situation well, but does not have to be a qualified professional. And we'll go over a little bit more about what that means. But basically, you know, if somebody has substance abuse disorder as part of their history and they're writing a reasonable accommodation request at move-in, then if maybe they're part of a 12-step program, their sponsor could definitely be somebody who provides verification. So while they're not a professional, they are still qualified. The verifier of the disability must also state that the reasonable accommodation or modification is necessary for equal access or enjoyment of the unit and establish a connection between the reasonable accommodation or modification and the disability. So, you know, it has to be, somebody could be living with a disability and their reasonable accommodation or modification request could have something to do with, you know, have nothing to do with their request. At that point, the housing provider might not meet that request. It has to be directly connected to the disability in order for the request to be met. But verifiers do not need to disclose the type of disability or the physical benefits of the reasonable accommodation or modification. So you don't have to give up, you know, personal information about someone's disability in order to write these verification letters. And when I show you that example of the letter, it'll become more clear about exactly what needs to be on that letter. Next slide, please. So who can provide the verification? You know, folks who are usually considered as qualified could be a doctor, a nurse, a counselor, psychologist, a social worker, a religious leader. A lot of times religious leaders are educated on how to counsel people, and so many people will lean into their religious leader for this kind of counseling, maybe even before they would lean into a medical provider. So that's why they're on this list. And again, like as I mentioned, a sponsor of a 12-step program. Folks who could be considered questionable might be a friend, a coworker, your grocery teller, I know another family member like a cousin or a parent. But you know, there is a caveat there. For example, if the parent is the primary caregiver or appointed caregiver of a child who has a disability, in some cases, they would be qualified to provide verification. So an example could be maybe they need to soundproof a unit for a child who's, because of their disability, they're making a lot of noise, right? Really what it comes down to is it going to hold up in court? And in some instances, we think it will for parents. And we always tell folks to be aware of those online predatory sources. The Department of Housing and Urban Development is very clear that these do not qualify as verification. What they are is a website where someone can go on. They don't ever meet with a professional. They don't ever talk to anybody. They just fill out a form about their situation, and then they pay a couple $100 and are able to print out something that they're saying is a verification for certified assistance animal, which is, there's really no such thing. Someone could definitely have a certified service animal who's trained to do a specific job, like a seeing eye dog. They wouldn't be printing that off of the website, somebody who's never met them or the animal. So really these verification letters can come from, a provider that knows them well or another qualified individual. But if it's just a website where really the housing provider can't call back and say, hey, did you provide this verification? And it's not somebody who knows the person's situation well, then they don't hold up in court. So again, really important that it's somebody who knows the person and understands what they're asking for. And at this point, I'd like to just pop up that verification letter if it's possible. Can we go ahead and share that real quick? Great, so there, it's in the chat there. If anybody wants to be able to go onto our website, and you can search third-party verification. You can find it there. And here it comes. Awesome, thank you so much. So this is right on our website. If you go to fhco.org and type in third-party verification, this will pop up. And it's created so that really it makes it easy not to give up too much personal information about someone's disability. So at the top, you would have the date, you would have your name and address as a provider, because the housing provider or a landlord can call back and say, hey, did you provide this verification? And is this what it said? And you can say yes. You don't have to give up any more information. If they're pressing you for more information, that's where you can say, I can't give you that information. And so I'm sorry, so it has the housing provider's name and address at the top, and then also your information goes below that. Then it would have the tenant's name, and it would say, this tenant has contacted me regarding their need for a reasonable accommodation. This tenant, which their name would go here, makes this request pursuant to the Fair Housing Act, which requires housing providers to make reasonable accommodations in existing rules, policies, practices, or services if such accommodations may be necessary to afford such persons full use and enjoyment of the premises. I have been informed that the accommodation they have requested is, and then you put in whatever the request is. Maybe the example again is to soundproof their unit, or maybe the example is that they need an assistance animal. Then they would say, I am aware of the nature and extent of, tenant's name goes here, of their disability, and I understand the reasons for their request for this reasonable accommodation. I do hereby verify that in my judgment, and then the tenant's name, is a qualified person with a disability as defined by the Fair Housing Act, and that the above stated reasonable accommodation is necessary to afford the person's name the opportunity to fully use and enjoy the premises as provided by the Fair Housing Act. Sincerely, medical provider's name and credentials, medical provider's contact information. And that's really all you have to provide. When somebody's making a reasonable accommodation request, the reasonable part of that is not the housing provider or landlord second guessing this third-party verification. That has more to do with the impact on the housing provider. So there are some reasons why they might not meet the housing, the request, but it would not have to do with the verification that you have provided. So we can go ahead and move on to the next slide, please. Oh, great. Yeah, so this tells you how to find that verification form. So it says you can go to our website, fhco.org, and then you would go up into the search function, which is the little magnifying glass at the top right of the page, and just type in third-party verification, and it'll bring up that same letter. You can fill it out and print it right there from your browser. So we try to make it pretty simple to use. You can also download it to have it for later use, or if you need to share it with another provider, then you can share it out. Great. Okay, next slide. So my last 2 slides are just some scenarios that somebody might come up against if they're providing verification. So some things to know. So the scenario is that a new client comes for an office visit and states they have a disability. They request that you write a verification letter for them for an assistance animal. What do you do? Well, there's a few things that you just need to consider. How long have you known the client? Can you verify that they meet the Fair Housing definition of disability through however long you've met them? You know, like maybe it's the first visit, but from that visit, you can identify these things. And can you verify that the animal would restore equal access or enjoyment of their housing, right? And with your professional knowledge, your qualified knowledge, if you can say, yes, I can verify these things, then you would be qualified to write the reasonable accommodation request. Even if if you feel like you can't meet those verifications, you're like, no, I'm just not sure, and you need to get to know the person a little better, then that would be understandable. And you might need to meet them a few more times until you can say, yes, now I can verify these things. So it's really up to your discretion on that. Okay, next scenario, thanks. So it's another assistance animal scenario. So you provide a client with an assistance animal verification letter. The client told you that they were going to get 1 dog, but then the client gets 3 dogs and the dogs are causing damage to the unit and violating their rental agreement. As the provider, are you liable? Well, no. The short answer is no. The applicant or tenant, the person making the request, is responsible for complying with their rental agreement. So having a disability, again, it does not exclude them from their responsibilities under that contract. If the client requested verification for 1 animal and that's what you provided, the liability is on the client for the damage to the unit and violations of the rental agreement. And what if the tenant only has 1 animal, but that 1 animal is causing damage? Just know that the responsibility still lies with the tenant, not with the provider, which I know that can be, I think it would be a little nerve-wracking, if you're writing these verifications and that kind of thing can happen if you didn't know the legality of the situation, but really it does, the responsibility falls back to the tenant. So just wanted to go over a couple of different scenarios, and my information will be provided to you all. If you have more questions about these verification letters, we'd be happy to take them later, and I'll be answering questions in the chat.
Jamie, that was wonderful. Thank you so much for that. So much information. And then we provided on the chat the third-party verification. Alma provided it via a link. Again, your questions are welcome. We're going to go over them. Hopefully, we'll have some time and space to address them at the end of the webinar. So continue providing them on the chat. We will address them. And up next, we have Michael with Bully. So Michael, I'll give it to you.
All right, good morning, everyone. Thank you. My name is Michael Sterner, he, him, his pronouns. I am the Fair Housing Enforcement Manager at BOLI, and BOLI is the Bureau of Labor and Industries, which is a state agency. Oh, thank you. Slide number 2 here. And the mission of BOLI is to protect employment rights, advance employment opportunities, and protect access to housing and public accommodations free from discrimination for all Oregonians. And we're a state agency led by a statewide elected labor commissioner. Currently, that's Christina Stevenson. And our Fair Housing Enforcement Unit is part of the Civil Rights Division of BOLI, and we have 4 investigators based around the state. At least one of them, Antonio Hernandez, is here with us today, and maybe a few others. We also have Cristo Jimenez and Lisa Lima in Central Oregon, and Ibrahim Koulibaly in Eugene. And I work at our main Portland office. Let's see. So the 4 principal duties of BOLI, you may be familiar with us through our employment work. We protect the rights of workers to equal non-discriminatory treatment through enforcement of anti-discrimination laws in the workplace, also in housing and public accommodations. We encourage and enforce compliance with state laws relating to wages, hours, and terms of condition of employment. And educate and train employers to understand and comply with both wage and hour and civil rights law. We do a lot of technical outreach. Any of your human resources departments would surely be familiar with the technical assistance that BOLI provides, and we can provide similar technical assistance if you have any questions about housing or about these disability confirmation letters or anything related to housing and fair housing. And we promote the development of highly skilled competitive workforce through our apprenticeship division. So next slide, please. So I'm not going to go over all of the gory details of Fair Housing Act because that has been well covered, at least on this particular issue, by our by Fair Housing Council of Oregon, and we work closely with Fair Housing Council of Oregon on these matters regularly, thankfully. And but basically, in summary, we enforce the state fair housing laws, which are substantially equivalent to the Federal Fair Housing Act. Those state laws are found in Oregon Revised Statute 659A, if you want to look them up. But essentially, fair housing is the right to choose and live in a home free from unlawful discrimination. And Oregon's laws protect people from being treated differently, as you learned, because of these protected classes. If you're a member of these protected classes, race, color, religion, sex, national origin, whether or not you have kids, disability, also source of income, marital status, sexual orientation, and gender identity. So next slide, please. For us, and I think this is true for the cases that Fair Housing Council sees and HUD, the most frequent basis of claims are because of members of these protected classes experiencing discrimination, and that is disability, sex, and subcategories that fall under that, and source of income, most frequently housing choice vouchers or other rent assistance, and fourthly, because of race or color. Next slide, please. And one thing that's important, as Jamie mentioned, to distinguish fair housing laws from landlord-tenant law is that fair housing law applies to all housing-related transactions. So that includes renting. It also includes the sale or financing of housing. It could be the sale of a vacant lot that is going to be where a house will be built. And it also relates to appraisals. So the valuation of housing can unfortunately be a source of discrimination. Let's see here. So here are some of the prohibited examples of prohibited actions. A person may not, because of race, color, and all of the protected classes, may not refuse to rent or sell, may not make a distinction in terms of price, may not discourage a person from renting or buying, may not advertise a preference of any kind. Although there are a few exclusions if the owner occupies the same dwelling that they're trying to rent. So it's like shared living space. Or if the shared space is going to result in sharing a bathroom or bedroom spaces. And then there are some carve-outs and exemptions from this where you can state as a preference that the renter be the same sex or whatever as the owner, if the owner is an occupant. You cannot cause another person to violate the fair housing laws. You cannot prevent a person from enjoying their right of use of a property. Another common source of complaints we see are tenant-on-tenant harassment, and landlords and property managers do have an obligation to be aware of that and to take steps to mitigate tenant-on-tenant harassment and discrimination. And that can be very challenging in those situations. A person may not deny access to a listing service for real estate, so that's just for real estate professionals, or represent the property is not available, or otherwise deny access to a property. So if a landlord denies a reasonable accommodation, that is effectively denying access or use of the property by a person with a disability, potentially. Okay, next slide, please. All right, I probably don't need to get into a whole lot of detail here because it has been well covered. Let's see here, but basically under 659A145, a person may not discriminate because of a disability by refusing to permit at the expense of the individual with the disability reasonable modifications. And again, those modifications are like physical changes to a property. Or under G, refusing to make reasonable accommodations in the rules, policies, and practices. And as was explained, reasonable accommodations are changes in policy or adaptations to allow a person to have an emotional support animal, for example, when the policy is no pets. That would be a reasonable accommodation. We also see requests for different kinds of heating or air conditioning, where there might be a policy of no window air conditioners. Now there's been a change in the law, so it's not really that much of an issue anymore. But there were policies saying you may not have a window air conditioner. Well, a person with a disability, if they may need additional cooling or ventilation, and so by allowing them to have a window air conditioner, that would be a reasonable accommodation, change in the policies to allow that person to have what they need to use and then fully enjoy the property. There's also a policy of failing to design a new building following the requirements of the Fair Housing Act. Okay, next slide, please. Let's see here. And I think here the role of healthcare providers, I should clearly explain that we at BOLI are neutral third-party investigators. Okay, when we receive complaints from the public, individuals or families who believe they've been discriminated against in housing, if they present a prima facie case of discrimination, then we will open an investigation that gives the landlord or other party, property manager, a chance to respond to us with their side of the story. We may request additional information, documentation. We may interview people. We do have the ability to subpoena witnesses and documents. We don't usually have to do that, but we can. And then we may dismiss a case because we don't find that there's discrimination, or we may make a determination that there's substantial evidence of discrimination, in which case we may, we always try to settle matters by mediating between the two parties. And a lot of times when we've got a case of, an emotional support animal is needed or a service animal is needed, that mediation, ideally would result in the complainant being able to get that animal that they need and stay in the property where they are. But sometimes it does take the intervention of a third party to get that to happen. Failing conciliation or settlement process, we may refer cases onto our administrative prosecution unit. They will take those cases to a administrative law judge. And those cases are appealable to the state appeals court, or a complainant may at any time decide to take the case out of the administrative review process and go to civil court, just the Oregon State Circuit Court. Basically, I think the role of healthcare providers here is, you have the right to request documentation of the need for the reasonable accommodation, and need to be familiar with the person coming to you making that request. You do need to see a link between the disability and the accommodation. And let's see here. Again, in a lot of cases, without that documentation, that letter, people who do need this accommodation will not get that accommodation from their housing provider, landlord, or property manager. And the effect could be that a denial is going to prevent that person from having full use and enjoyment of the property that they're renting, of their home. They may have poor health outcomes. They may need to move. This all may result in homelessness. I mean, I don't think I need to elaborate on the risks of that in the current housing market that we're in. So I think it is really important, but I think, as Jamie explained, you don't need to agree to anything that you don't believe is true. If you don't see the connection between the disability, you can use your judgment as a professional. So I'm not sure how we're doing on time here, but I could wrap it up. I'm not sure. I think there might be one more slide here. And here is how to reach us. There's information both for complainants or for housing providers. And I think there's a lot of information on our website that'll be relevant if you have questions in general about, just as a medical provider or mental health professional, information about what fair housing is, what the policies are in Oregon, both on our website and the HUD, Housing and Urban Development websites. But for filing a complaint, you can access that at this website. There's a full questionnaire to be filled out by a complainant. We'll review those and they get assigned to an investigator. And that investigator would reach out to the complainant within, a relatively short time. So again, here's my contact information. Here's our website. And thank you very much.
Michael, thank you for providing this important information. I do see some questions being answered on the chat, but at this time, I am going to pass it on to my colleague Alma to address some of those questions and see if we can maybe share with everybody on here, or if anybody would like to come unmute. We do have a few minutes before we jump onto OHP Healthier Oregon updates. So yeah, I'll just pass it on to you, Alma.
Hi, Rosie. Thank you. Let me get my chat screen up. Kind of got quite a bit going on with the PowerPoint. So let me go back. And looks like I'm going to start with the last question just because it'll be easier to navigate. So the last question we got in is, can peers help with recovery letters? And the response was, it is depending on their relationship to the person making the request. JB responded, I'd say it's more likely to hold up in court if that person is a sponsor in a 12-step program or a drug and alcohol counselor, someone who is working with the person or serving their needs around the disability, which could be alcoholism, substance abuse disorder. And I do see a request for a link in the chat. JD, can you let us know exactly what link you're requesting so we can make sure we get that information?
Not a problem. The last presenter had a long link on the slide before their information. And unfortunately, we can't click on that from the slide.
Okay, we will be sharing the slide deck with everyone in the follow-up email. So you will have access to all these resources and information that we're sharing today. But Michael, if you're able to and wouldn't mind, can you please pop that link in the chat?
Actually, I'll take care of it. I have it up here. So
Okay.
I know which one she's talking about. Thanks,
Perfect.
JD.
Thank you, Rosie.
Great, thanks.
And I'm trying to go through the questions box. Are there any other new questions that haven't been answered in the chat box yet that we would like to get to? Feel free to raise your hand if you have a question. And when I say raise your hand, it could be your virtual hand or your real hand if your camera is up. And we know there might be some questions that will come up later, and we'll provide contact information for everyone who joined us today. So if and when you get a chance to process all of this information or have a case to staff, you'll be able to reach out to those specific parties. I'm not seeing anything new come in, so I'm going to move us along just because of the interest of time, and I don't want to keep everyone longer than I have to. So next, we're going to jump into our OHP announcements that we have for all of you today. As Rosie mentioned, it is relevant to Healthier Oregon expansion. So effective July 1st, 2023, full OHP benefits will open to people of any age or immigration status. Right now, this is approximately 40,000 individuals who are currently enrolled in citizenship waived medical benefits. for ages 26 to 54. These individuals will move from their emergency level coverage to full OHP benefits as of July 1st. So these members will now be able to access and receive services that was previously limited by Citizen Wave Medical, which we all refer to as emergency coverage only. This will open up services such as preventative care, mammograms, colonoscopies, diagnostic labs, dental services, without those limitations that we were seeing, just to name a few. And what can members and providers expect? So members will be receiving notices of eligibility, their welcome packets, and benefit information. As a provider, you'll be seeing these individuals coming into your office, probably with those notices, with their new cards, and a lot of questions on how to use this benefit since they haven't had it before and have only usually used emergency room level services. So we know that you'll be getting hit with a lot of questions. Support staff, billing staff will have a lot of questions, and we want to make sure that we're providing your team and everyone the support that they need. So some of the things that we've done is partnering with organizations statewide who can help support these Healthier Oregon members. Our grantee partners have already been and will continue to do this work. Most of our grantee partners currently are trained as community health workers and are given the opportunity for continuing education credits if they're already community health workers. So we really want to make sure that we're preparing the staff that we partner with and those community partners to better support these members in understanding their benefits, using their benefits, and helping provider offices as well. For you to find a local grantee, we have a couple of resources. We have our Healthier Oregon website, which we have listed here, and you will get in the follow-up email, where you can go in and find a community partner that can help these members utilize their benefits and understand the information that they're receiving from the state and the information they'll also be receiving from the CCOs that they will be assigned to. Other than that, I don't have anything else to add to that. Just want to remind you, we'll have a lot more communications and materials coming out regarding Healthier Oregon and mechanisms to support these members and provider offices and community partners statewide. So please be on the lookout. We'll be sharing it via emails that we send out, newsletters. I know we, as CPOP, we have our CP update newsletter we send out. We also partner with another program that sends a Provider Matters newsletter, which we hope to share communications, radio, social media. So we'll be trying to do as much as we can to share information with all of you.
We have a couple of questions, Alma, on the chat. The first one, do they need to refile? I'm thinking this is kind of applying for a new application, right, JD, for Healthier Oregon. And they're going to do the same process that they did last year for folks 19 to 25 and those 55 and older. So whoever was with had CAWM benefits, they would transition, the system would transition them to full OHP benefits. They are planning on doing the same thing this time around. So if anybody doesn't have CAWM, they would need to apply for OHP in order to be eligible for that. And of course, they would have to meet all other eligibility criteria in order to be considered for OHP. But the immigration status is not something that would be an eligibility factor to get OHP. And there was another question. How does a CHW access the CEUs? I am not sure what that means, but you might.
That's a great question, JD. Right now, I don't have that information on hand. We do have a team that is working specifically with our CHWs. I would ask that if you are a CHW, I'm going to share contact information, and this will give you an idea of who to reach out to. So that's a good segue. For any specific, oh, looks like we're missing our community outreach email here. Rosie, do you mind dropping that one in? I was going to share that as a contact. So JD, if you have specific questions, feel free to email our community.outreach at odhsoha.oregon.gov email inbox, and we can help provide more information on how you can tap into those resources. Rosie did share that in the chat box for everyone, but here I did want to share the rest of the contact information for those who were able to join us today, help provide information, and who can be continuous support going forward with anything related to the Fair Housing Act, ag, disability, modifications, and anything that we discussed today. And as well, highlighting Doctora Andrea Lara, who is our provider outreach and engagement strategist with the Community Partner Outreach Program, who will be a great contact going forward for all of our providers who may have questions regarding to tapping into resources that affect providers and the work that they do. And I will let Rosie and Doctora Lara add more before we end for today.
All right, thank you, Alma. I don't have anything else to add. All contact information from our speakers is available here. Again, you may have questions after the webinar. Feel free to reach out via email community.outreach@oha.oregon.gov. Let us know those questions. We'll be able to do a Q&A, follow up with that Q&A. I know some of you were interested in the recording. That may take a little bit longer to get, but for sure, once we get it, and if we get it in time, you'll be able to receive that during the follow-up email as well. Other than that, I'll just hand it out, off to Doctora Lara for her final closing.
So we want to thank you to Jamie, Michael, Evita, Holly, and all the interpreters here. It was a pleasure to meet everybody, and hopefully we are going to meet again probably next month, so we can have more OHP extension news. So this is really exciting for us. Extending the program is really a huge news for us, and we're really happy to share with you. So please reach out to our emails, and we thank you again for this time. See you next time.
All right, have a good lunch, you guys. Thank you so much for joining us today. Happy Wednesday.
Thank you, everyone.
Talk soon.